this deputy medical examiner, if he could rule out that Celeste may have inflicted both of these stab wounds on her own. And he said, based on his findings in this autopsy, that was not something that he could definitively.
The deputy medical examiner, Dr. Grant Ho, took the stand and in a methodical, almost detached tone, described the condition of the remains as he first saw them. He noted the beginning stages of maggot activity. He documented the disarticulation of limbs. He pointed to a disruption on the left lateral chest and a penetrating injury to the abdomen. His testimony, delivered in the flat cadence of a man who does this every day, painted a picture of a body that had been disassembled. Then, under cross-examination, he delivered the line that didn't just stun the courtroom. It detonated the prosecution's entire theory of the case in a single, quiet admission. When asked if he could definitively rule out that the fatal wounds were self-inflicted, he said he could not. Think of a ruler laid flat against a photograph of a wound. The medical examiner is measuring the gap between what the tissue shows and what the law requires him to say is absolute. That gap, measured in millimeters of decomposed flesh, is where a first-degree murder charge with a sharp instrument enhancement begins to dissolve into something far more ambiguous than the affidavit ever suggested. The ruler doesn't lie, but it also doesn't tell you the whole story. It just measures the distance between certainty and doubt. Before we go deeper into what the documents actually show, make sure you're subscribed to Crime Files 9/11, because we don't just cover the story, we follow the evidence. The direct examination was a clinical march through trauma. Dr. Ho confirmed the cause of death as multiple penetrating injuries and the manner as homicide. But then came the qualifier, and it is a qualifier that defense attorney Marilyn Bidnarski seized upon with surgical precision. The autopsy report does not classify the weapon as a sharp instrument. The language is deliberately, legally vague.
They decided the cause and manner of death of 14-year-old Celeste Rivas Hernandez was homicide, and they attributed her death to multiple penetrating injuries. Here's what's interesting, though. They did not identify what kind of weapon or tool caused those penetrating injuries. And they stopped short of actually calling it a penetrating injury caused by a sharp instrument. So they're not saying that she was definitely stabbed to death. And that's because of the advanced state of decomposition. They simply don't know for sure exactly how or what caused a lot of what they found, which we are looking at right now in the courtroom, documented in these very, very visual exhibits.
Let me tell you why that's so significant. You know, but our audience should know. One of the special circumstance allegations in this case that has been presented by prosecutors is that David Anthony Burke personally used a deadly and dangerous weapon, a sharp instrument, to commit this crime. And yet what you're telling us is this deputy medical examiner can't definitively say that that's the case.
We don't know that for sure. And I think defense attorneys made a point of underscoring that several times.
The reason is decomposition. The body, found in an advanced state of decay after being stored in a confined space, had simply lost the structural integrity required for a pathologist to say with medical certainty that a knife did this. The tissue retracted, the edges of the wounds changed post-mortem. What looks like a stab wound to a layperson looking at a projected autopsy photo, and the gasps in that gallery confirmed how visceral those photos were, is under the rigid definitions of forensic pathology, just a penetrating injury of unknown origin.
There was an audible reaction, there was a visceral reaction, and let me describe to you what happened, possibly by accident. Before we were actually shown the exhibits that we were supposed to see in the order that they were supposed to be presented, during this deputy medical examiner's testimony, the projector in the courtroom actually flipped through numerous autopsy photos before we were supposed to see that. So imagine, right, this overhead monitor, kind of like flipbook style, in a matter of seconds, going through probably about half a dozen photos. And I'm talking autopsy photos, showing the victim's torso, open chest cavity, extremities, laid out, cleaned off and laid out on a silver exam table. There was an audible gasp. A reporter sitting behind me in the courtroom, you could hear her reacting to this. You could see everybody reacting, I think, very viscerally. but Dr. Grant Ho, the witness on the stand right now, he's going through this methodically, step by step. For him, this is his day-to-day. This is...
The prosecution has charged a special circumstance alleging the personal use of a deadly and dangerous weapon, a sharp instrument, and their own witness, their own deputy medical examiner, told the court that the science cannot confirm that instrument was a knife, a shard of glass, a screwdriver, or even a bullet that passed clean through, leaving an exit wound that can no longer be distinguished from postmortem insect activity. The paperwork already knew. The forensic pivot in this hearing occurred not when the photos went up, but when the questioning turned to the ribs. Dr. Ho described damage to the left rib cage. He described a cut that would require, in his estimation, something like hedge cutters to sever bone. But when pressed on the penetrating injuries that actually ended this victim's life, the wound track near the liver, the track near the diaphragm, he conceded a series of interconnected unknowns. He does not know which wound came first. He cannot say if they were separated by seconds or minutes. He cannot medically determine which of the two injuries was the fatal one. He cannot estimate a survival time. The window of death is not a window, it is an open door that the defense is now walking straight through. The argument wasn't shouted. It was placed gently before the court like a sealed exhibit. If the wounds could not be sequenced, if the victim could have survived one but not the other, and if the origin of those wounds cannot be definitively assigned to another person's hand, what exactly constitutes proof of murder beyond a reasonable doubt?
Yesterday, about the digital evidence left behind by David's Tesla and his iPhone, we heard about the exact timing and the approximate location of where both his phone and his Tesla were tracked, leaving his home and then going up north toward Santa Barbara County. That's, of course, where he is accused of dumping evidence related to this case. But defense, right, they jumped in immediately on cross and said, you cannot prove David was actually the one in the car. You cannot prove David was actually the one using his own phone. But there was an outgoing call about an hour, maybe an hour and a half after Celeste would have been dropped off at his home in the Hollywood Hills from David's iPhone to her number. But again, like defense attorneys noted, nobody can prove just yet that David was actually the one who made that call that went to voicemail. I think prosecution brought that up.
Let that sit for a moment. We aren't just talking about a forensic technicality. We are talking about the structural integrity of a death penalty eligible case. If this case proceeds to trial, a jury will be shown images that provoked an audible, visceral reaction from reporters and spectators, images of an open chest cavity, of limbs laid out on a silver examination table. They will see the aftermath of a body reduced to parts, and then the defense will rise and remind them that dismemberment, however grotesque, is not murder. The mutilation charge is separate. It is postmortem. The chainsaws recovered from the garage tested negative for blood. The one chainsaw that may be missing cannot be entered into evidence. The timeline the prosecution is building relies on a Tesla's telematics and iPhone's location data, not a murder weapon. The vehicle went north. The phone made a call that went to voicemail. But as the defense hammered on cross, nobody can prove the defendant was the person holding that phone. Nobody can prove he was the person driving that car. The digital evidence places the property, not the person.
Penalty. Here's what else the deputy medical examiner doesn't know for sure. And defense leaned really hard into all of this on cross. They don't know which penetrating injury occurred first. There's one on the victim's abdomen, and there's one on her lateral left chest. So one is associated possibly with liver damage, the other possibly with rib damage and diaphragm damage. Deputy Emmy can't say which one happened first. He can't say definitively whether or not they may have happened seconds apart. He cannot say which one caused her death. He cannot say how long it may have taken Celeste to die from either one of those injuries. There's so much we simply don't know. And that created a gap for one of the defense attorneys.
And if you strip away the property, you are left with a gruesome discovery in a frunk, a 3-month delay on the autopsy pending toxicology, and a toxicology report that came back inconclusive for methamphetamine, negative for benzodiazepines, and with an ethanol level so low the pathologist admitted it could have been produced by the body's own decomposition. The parallel narrative the defense is testing isn't a coherent counter story yet. It's a stress test. They are probing for the exact pressure point where the prosecution's narrative fractures. Bidnarski asked whether the medical examiner had investigated the decedent's mental health history. She asked whether he had spoken to family members about suicidal ideation.
To know first, is it helpful for somebody doing an autopsy to maybe have information about whether the decedent has a mental health history? Is it helpful to know if they are suicidal? Is it helpful to know if they are habitual drug users? So to each of those questions, Dr. Ho answered, potentially. So then she asked him, did you have any conversations with the decedent's relatives to explore those characteristics? He did not. So then she proceeded to ask about the injuries, right? The documented injuries.
She asked if he was aware of any habitual drug use. To each, the answer was either potentially or a flat no. The implication hung in the air like dust after a slammed door. The investigation, by its own admission, did not fully rule out an alternative scenario before certifying a homicide. The deputy medical examiner was clear that the advanced state of decomposition precludes a lot of definitive information. And then she asked the question that caused reporters to glance at each other, eyebrows raised. Can you rule out that the decedent inflicted these wounds upon herself? He could not. Not definitively. Not based on the physical evidence on his table. Nobody asked. Nobody answered.
And there was also a discussion about the chainsaws, right? So in other words, yesterday and the past few days, we know that chainsaws were collected, but as far as we know, they tested negative for blood. There seems to be one chainsaw that may be missing. In terms of a chainsaw potentially being used to inflict these injuries on Celeste, whether it was in the form of, her cause of death, maybe to kill her or to dismember her, what was the discussion of chainsaws today?
So the witness was very careful to answer that line of questioning. He noted, I think, several times that he is not an expert when it comes to tools, power tools used to dismember bodies. He did offer up some general knowledge about what might lead to the types of cuts that he noted on the victim's body. He described it as clean or smooth around the edges. That, though, I think is going to be called into question as well, because the appearance of all of these wounds, right, they have changed post-mortem during decomposition. But he talked about how to cut through soft tissue or organs, you can do that with a scalpel. He talked about how to cut through bone, you might use something like a bone saw. And he said to cut through rib, you would need something essentially like hedge cutters. That's what he said on the stand. Still, he cannot definitively identify what was used to sever this victim's limbs from her body.
And to be clear, the prosecution hasn't laid out a specific murder weapon or what happened to a potential murder weapon.
Consider the reaction that followed. It felt, to those in the room, like a line of questioning bordering on the absurd. But in a preliminary hearing, absurdity is not the standard, probable cause is. And what Bidnarski was doing was far more sophisticated than simply suggesting a teenage girl inflicted 2 fatal penetrating wounds on her own torso, and then someone panicked and dismembered her body. She was mapping the outer boundary of reasonable doubt. She was building a moat around the murder charge by demonstrating that every single physical conclusion the medical examiner drew stopped short of the certainty required for a sharp instrument enhancement. For a sequenced fatal attack, for an excluded alternative. The prosecution's case for murder at this precise moment hangs not on a smoking gun but on a collection of horrific circumstantial imagery that the law requires a jury to interpret as the only logical explanation. The defense is ceding the ground for another explanation, however faint, that the forensic pathology cannot eliminate.
Referenced. Now, there was a question about that delay, right? 3-month delay. And Dr. Grant Ho explained very clearly on the stand, it was because they had to do some ancillary testing. They were basically waiting for the toxicology testing to be done because they wanted to rule out that an overdose played a role in her death. Once they got that toxicology report back, and all they found was inconclusive for methamphetamine, negative ultimately for benzos, and a very, very low detection of ethanol in her liver that Dr. Ho says may have actually been produced by the body itself as it was decomposing. After they got those results back, they went ahead and they attributed her death to the multiple penetrating injuries. So basically, they had to wait a couple.
And what of the insect activity? Dr. Ho described the beginning stages of maggot colonization when he received the remains. He gave it no emotional weight, just the detached observation of a man cataloging nature's reclamation process. But that detail does something specific in the legal timeline. It speaks to the interval between death and discovery, an interval the defense is already exploiting to question whether the date of death can be precisely fixed to that April night. If the entomological evidence suggests a window, and that window is even slightly misaligned with the digital evidence of the Uber ride and the single outgoing call, the chronology of the prosecution's narrative develops a stress fracture.
Jesse, I don't know if that's where the defense is actively trying to go. I think this is their opportunity during this preliminary hearing to kind of test out different lines of questioning, right? See what sticks. See where the biggest openings might be for them to just create more gaps in the prosecution's case. I don't believe that line of questioning is going to go anywhere. But here's how they laid it out this morning. Marilyn Bidnarski was the one asking Dr. Grant Ho these questions. She wanted to know first, is it helpful for somebody doing an autopsy to maybe have information about whether the decedent has a mental health history? Is it helpful to know if they are suicidal? Is it helpful to know if they are habitual drug users? So to each of those questions, Dr. Ho answered, potentially. So then she asked him, did you have any conversations with the decedent's relatives to explore those characteristics? He did not. So then she proceeded to ask about the injuries, right? The documented injuries, these penetrating wounds, the disruption to one of her ribs, the damage noted on her liver. And the defense wants to know, can you definitively link those observations that were made during the autopsy to what you see on the overlaying skin? And do you know exactly how that occurred? Are you able to definitively report that somebody else caused those injuries?
And yet the pathologist who performed the autopsy cannot describe the object that made them, the hand that held it, or the order in which the damage was inflicted. The paperwork already knew. Here is the question that transforms this hearing from a legal proceeding into a national security of justice moment. If the forensic evidence is this physically limited, this decomposed, and this open to alternative interpretation, can a jury convict a man of first-degree murder with special circumstances, exposing him to the death penalty, on the sheer weight of the revulsion they feel when they see what was left of a 14-year-old girl's body in the front trunk of a luxury electric vehicle? The visual horror is the prosecution's most powerful asset, and it is also the most legally vulnerable. Juries are human. The gasps in the courtroom were human. But the law demands a chain of inferences so tight that no reasonable alternative can breathe. The defense just cracked a window. The clean cuts on the bone are another vector of ambiguity. Dr. Ho testified that he was not an expert in power tools, a careful demurral that shields him from being pinned down on whether the dismemberment was accomplished with the specific saws recovered from the garage. He described smooth edges. He described what a scalpel can do to soft tissue and what a bone saw or hedge cutters can do to rib. But he could not match the tool marks to a specific instrument in evidence because no such instrument has been definitively tied to the act. The chainsaws tested negative for blood. The state has not presented a murder weapon. They have not presented an eyewitness. They have not presented a confession. They have presented a timeline, a Tesla, a set of horrific photographs, and a medical examiner who, under oath, acknowledged that his own findings are riddled with forensic caveats. Nobody asked. Nobody answered. The prosecution may still clear the low bar of probable cause. 51%. More likely than not. That is the whispered calculation in the hallway.
That was another detail that I think got a visible reaction in the courtroom this morning. Dr. Ho described the beginning stages of maggots all around the victim's remains when he first got the case, when he was preparing to do the autopsy. I think it was a good morning for the victim's parents, both of her parents, who've been sitting in for most of this preliminary hearing to not be in the courtroom. I walked past them in the hallway just now when I was exiting for lunch. They are here, they are in the courthouse, but they elected not to sit in there this morning for this testimony. I think that was a an understandable move on their part.
Deputy DA Beth Silverman appeared relaxed, even unbothered by the forensic concessions. She knows she doesn't need to prove the case beyond a reasonable doubt today. She just needs to show that a crime occurred and that the defendant is likely connected to it. But the defense is not playing for today. The defense is building the scaffolding of an appeal. They are constructing the cross-examination for a trial that may be a year away. They are locking the medical examiner into statements about what he cannot say, statements that will be read back to a future jury word for word. The pathologist who cannot rule out self-infliction, who cannot identify a weapon, who cannot sequence the wounds. That witness does not just belong to the prosecution. He now belongs to the record. The visual anchor of this entire proceeding is not the photographs, as shocking as they were when the projector accidentally flipped through them like a macabre flipbook of an open torso and cleaned extremities. The visual anchor is the gap itself. It is the space between the prosecution's charging language, sharp instrument, personally used, murder, and the medical language of the sworn testimony. Penetrating injury, unknown origin, cannot rule out. That gap is the exact shape of reasonable doubt. It is a void that the state must fill with circumstantial evidence so airtight that 12 people will choose to stare at those autopsy photos and see not just tragedy but intent, not just dismemberment, but a fatal hand holding a definable blade. The physical evidence, as it stands, shows them only the aftermath. The body kept its secrets through decomposition, and now the law must decide if those secrets are fatal to the case itself. We will be tracking the final day of this preliminary hearing and the judges ruling on whether this proceeds to trial. The standard is low, but the implications are absolute. If you want to follow the evidence yourself, I am directing you the publicly filed autopsy report for Celeste Rivas Hernandez, Los Angeles County Medical Examiner, coroner case number 2024-04152. Read the findings on the penetrating injuries. Look at the listed manner of death against the caveats regarding the instrument. And then tell me in the comments, does the medical ambiguity in this report support a death penalty prosecution? Or does it reveal a structural weakness that no amount of photographic horror can repair? If you made it this far, you're the kind of viewer who understands that justice doesn't happen in sound bites. It happens in sworn testimony, in cross-examination, and in the quiet moments where a medical examiner admits the limits of his own science. Like this video, share it with someone who needs to hear the actual evidence instead of the headlines. Subscribe to Crime Files 9 or 11 and turn on notifications. We will see you on the next file.